There are 4 different defenses that can be used, which are self-defense, duress by threats, duress of circumstances and necessity, and consent. The defense of self-defense is a legal justification that allows a person to use force to protect themselves, another person, or property from an unlawful attack. The first element of self-defense is that the defendant must be facing an unlawful threat, as shown in R v Gladstone-Williams, where the defendant mistakenly believed someone was being assaulted. The second element of self-defense is that the force used must be necessary, as shown in R v Bird, where the defendant was not required to retreat before defending herself. The third element of self-defense is that the force used must be reasonable in the circumstances, as shown in R v Palmer, where the court held that a person defending themselves cannot be expected to weigh the exact measure of force in the heat of the moment. Self-defense can be applied under both common law and statute, including the Criminal Law Act 1967 and the Criminal Justice and Immigration Act 2008, where it protects those who use necessary and proportionate force. Reasonable and necessary force means the level of force used must match the circumstances as the defendant honestly believed them to be, as shown in R v O, where the court stated that the force must be objectively reasonable in the circumstances. The defense of duress by threats is a complete defense that excuses a defendant who commits a crime because they were forced to do so by threats of death or serious injury. The first element of duress by threats is that the defendant must face a threat of death or serious injury, as shown in R v Valderrama-Vega, where other pressures were ignored unless the threat involved death or serious harm. The second element of duress by threats is that the threat must be directed towards the defendant, their immediate family, or someone they are responsible for, as shown in R v Wright, where threats to a boyfriend were considered sufficient. The third element of duress by threats is that a reasonable and sober person with the same characteristics as the defendant would have acted in the same way, as shown in R v Bowen, where characteristics such as age and gender were considered relevant. The fourth element of duress by threats is that the defendant must have no safe avenue of escape, as shown in R v Gill, where the defense failed because the defendant had a chance to go to the police. The fifth element of duress by threats is that the threat must be operative at the time of the offense, as shown in R v Hudson and Taylor, where the court accepted that the threats could still influence the defendants even when not immediate. The defenses of duress of circumstance and necessity both excuse a defendant who commits a crime to avoid a greater harm, but duress of circumstance involves threats arising from the situation, while necessity involves choosing the lesser of two evils. The defense of duress of circumstance allows a defendant to commit a crime because of a threat created by the surrounding circumstances rather than a person. The first element of duress of circumstance is that the defendant must reasonably believe they or another are facing death or serious injury, as shown in R v Martin, Colin, where the defendant drove while disqualified to save his suicidal wife. The second element of duress of circumstance is that a sober and reasonable person sharing the defendant's characteristics would have acted the same way, as shown in R v Conway, where the defendant drove dangerously believing his passenger was about to be shot. The defense of duress of necessity allows a defendant to commit a crime to prevent a greater harm from occurring. The first element of duress of necessity is that the act must be done only to prevent inevitable and irreparable evil, as shown in Re F. Mental patient, sterilization, where doctors acted to protect a patient from harm. The second element of duress of necessity is that the act must be reasonable and proportionate to the harm avoided, as shown in Re A. Conjoined twins, where separating the twins was necessary to save one of their lives. The defense of consent is a defense that allows a defendant to avoid liability if the victim freely and genuinely agreed to the act that caused harm. The first element of consent is that the victim must give valid and informed consent, as shown in R v Thibasum, where the consent was invalid because the victims were deceived about the nature of the act. The second element of consent is that the consent must be genuine and not obtained through fraud, fear, or mistake, as shown in R v Richardson, where a suspended dentist's patient still gave valid consent because they knew his identity. The third element of consent is that it is generally not a defense to actual bodily harm or greater injuries unless the activity falls within an accepted exception, as shown in R v Brown, where consent was not accepted for sadomasochistic acts causing injury. The fourth element of consent is that it may be valid in activities like sport, medical treatment, or lawful correction, as shown in R v Barnes, where injuries sustained during a football match were considered potentially lawful due to implied consent. Thank you for watching this video on general defenses. I'll see you in the next one.